we are proudly presenting to you actually a legal panel. So the topic here is artificial intelligence and human rights law in the here and now. And my very pleasant task is to introduce the moderator of this panel, Vivek Krishnamurthy, to you, who is also a major engine of support behind having this conference together. Both his early enthusiasm and his actual organizational work have been quite crucial for this event. So I'm very grateful for that. Vivek is, as I mentioned earlier already in my own talk this morning, he was at the Carr-Ryan Center until fairly recently. Technically, you still are there, right? So he's affiliated and technically also affiliated with us. So we're doing great things together here. And in particular, he, in that capacity, was a co-author of a report commissioned by the Canadian government about the human rights implications of artificial intelligence. To its great credit, the Canadian government is interested in such things, and it's a wonderful report also to read if you're interested in that question, the human rights impact on human rights in the here and now. So the here and now is very well taken, and since then Vivek has also taken up a position at Foley Hoag law firm, where he has started fascinating work to actually build activities around artificial intelligence from within that law firm. So without further ado, please join me in welcoming Vivek Krishnamurthy, who will introduce the other panelists then.
Thank you, Matthias, for that wonderful introduction. I'm delighted to be here. I'm delighted to be moderating this panel, which I think is going to be up to the task of following not only Matthias's dynamic presentation, but the heaviness of an Indian lunch. So we'll try to keep it light and interesting as all of you deal with the dal makhani. So it is my immense pleasure to introduce four distinguished panelists who will speak about artificial intelligence and human rights from the legal perspective. So we're taking the short view rather than the medium or long view. So right next to me is Yeginsu, who is a barrister at 40 Square Chambers in London, who litigates on human rights cases and also does international arbitration work. This semester, he is teaching with another one of our panelists, I'll introduce in a moment, at Columbia and at Georgetown. So Columbia on international free expression issues, and at Georgetown teaching international investment law. Next to him is Amy Lehr, my former colleague at Foley Hoag, but now the director of the Human Rights Program at the Center for Strategic and International Studies in Washington, D.C. Amy is a graduate of Harvard Law School, and after she graduated, spent quite some time working with John Ruggie, who was then the special representative for business and human rights appointed by Kofi Annan, and is thus one of the unacknowledged authors and intellectual forces behind the UN Guiding Principles on Business and Human Rights. More on that in the panel. Next to her is Nani, Jansen, and Reventlow. Reventlow, you corrected it, now I got it. Second time's a charm. Who is the director of the Digital Freedom Fund, which is a brand new impact litigation group in Berlin, based in Berlin, that seeks to bring important cases to advance digital rights, which are a form of human rights, as your topic says. Nani is a Dutch and English lawyer, and previously was a fellow of the Carr-Ryan Center at Harvard, and a colleague of mine in the Harvard Law School Cyber Law Clinic as well. Last but not least is Michael Karamian, who is a human rights, let me get this correct, human rights program manager at Microsoft, based in New York. And Michael is going to tell us about Microsoft's approach as a business to considering its human rights responsibility vis-a-vis the powerful artificial intelligences that it is developing. So, to begin, what we're going to do is have each of the panelists speak, deliver some short remarks of about 5 minutes, and then we'll have a little discussion in the panel before opening it up to your questions and comments. So, maybe I'll get John to set the stage here and so we've talked about human rights throughout the course of this conference from a number of different perspectives. I'd like you to introduce us to the concept of human rights as law. So please take it away.
Law. Well, the Universal Declaration is the obvious starting point. But let's not forget that the Universal Declaration is not itself a legally binding instrument. It is, however, the template, the source for all of the human rights that are binding, that we find at the international level, at the regional level, and at the domestic level. So at the international level, the International Covenant on Civil and Political Rights, the regional level, the African Charter, the European Convention, and domestically, of course, in various constitutions, written and unwritten, around the world. Human rights as law, I think the important starting point is to acknowledge that unlike other areas of law, the rights themselves, or the codes of rights, are very, very short. So you have a tax code, 500 pages. You have the Universal Declaration, 1 page. And a conscious decision was taken following the Second World War to draft a number of very important, unalienable rights at the general level, so general as to give judges and others interpreting these rights the flexibility so that these rights remain living instruments and don't become anachronistic in the light of technological or social or political developments. Very few of these rights are absolute. Most of them are qualified. The right against torture is an absolute right, one of the rare instances. But for instance, the right to freedom of expression is a qualified right. What does that mean for our purposes in AI? It means that there is an individual's right which needs to be balanced with perhaps other rights, or perhaps wider concerns such as public health or national security. So when we talk about human rights as law, we're really talking about balancing. And that will come on to why that leads to particularly interesting questions in the context of human rights and artificial intelligence. But one concept that I think we must all bear in mind when we're talking about balancing is, how does one achieve a fair balance? And that used to be really the preserve of judges who had to deal with that sort of balancing. But I think it's a much wider question now that human rights apply more widely than the drafters of the Universal Declaration probably thought they would when they drafted it. So that's just an introduction as to human rights as law. What's quite interesting is to see how the language of the Universal Declaration really does find itself even in domestic systems and regional systems. But of course, you do not have one body interpreting these common standards. So I think I'll just leave it there for now. And Vivek, we move on to...
Yes, thank you. So with that framework, I think Nani's going to add to it. So talking a bit about the work you've been doing at the Digital Freedom Fund to look at the application of these broad human rights principles in the digital context, particularly with regard to AI. And also, I know you've been doing some thinking about whether we're at a conference celebrating the 70th anniversary of the UDHR, whether those rights have stood the test of time.
Thank you. To answer that question, I do think that the Universal Declaration has stood the test of time pretty well, actually, because it is drafted as a technology-neutral document, right? And as John mentioned, it's very high level. So that was very clever by the drafters at the time. Some examples of kind of this framework being brought into the fray by different international bodies. Very recently, the UN Special Rapporteur on Extreme Poverty and Human Rights paid a country visit to the United Kingdom. You may have read about this in the news, but he was fairly critical about the use of technology by the UK government. And I will take the liberty of reading a little bit from his statement. He said that the UK has a policy of placing post-war welfare system behind a web page and an algorithm, and that government is increasingly automating itself with the use of data and new technology tools, including AI. And that evidence shows that the human rights of the poorest and most vulnerable are especially at risk in such context. The Special Rapporteur said similar things based on in a country report about the United States. And there it said that experience shows that the poor are often a testing ground for practices and policies that may then be applied to others. And this is what he said on the use of big data, machine learning, and algorithmic decision making in the US context. The UN High Commissioner on Human Rights issued a report on the gender digital divide and AI. And in that he basically latched on to standards from the Universal Declaration, right? Saying that the use of such technology should be transparent and accountable, that it should be human rights compliant, and that data input should be inclusive and accurate. And the UN Human Rights Council, of course, also issued a resolution on the right to privacy in a digital age. But, you know, the Universal Declaration being technology neutral notwithstanding, there could perhaps be reasons to kind of reconsider if that framework is really fully applicable and is sufficient for the context that we have right now with technological developments taking place. And there's been various efforts, right, to kind of look at a reframing of kind of the standards network. The Internet Rights and Principles Coalition has drafted a Charter of Human Rights and Principles for the Internet. Article 19 has drafted a Universal Declaration of Digital Rights. And the Zeitstiftung has made a European version, basically, of that, the European Digital Charter. In the context of the Digital Freedom Fund, we focus on Europe only at the moment. We've been also thinking about what the future of digital rights really means. And we've had a series of meetings with organizations from our network, which included also reflections on like what would a future Universal Declaration of Digital Rights actually look like. And by digital rights, as Vivek also already said, is like we consider human rights in the broadest spectrum, so the entire Universal Declaration basically, but exercised and applicable in the digital sphere. And I just wanted to, flag here some of the ideas that came out of our brainstorming sessions, but have also been flagged in some of these other initiatives. So some of these were, perhaps the right to understand implications of technology, the right to opt out of profiling, the right to algorithmic transparency, the right to request human override to algorithmic justice, or the right not to be judged by a machine. So the big question there is, are these actually new rights, or are these specifications of the rights that we already have in the framework? And I guess that this is one of the things that that we'll have to kind of see over time as we see international bodies and courts apply these standards in the new context, right? Are they able to be flexible, and do they understand technology sufficiently to be able to do justice to the protections that the original drafters of the Universal Declaration intended to give? So I'll pause there.
Thank you, Nani. So what we've discussed so far in terms of the classic human rights system is a system where the duties to protect human rights are fundamentally those of states. Now, leading development in human rights in the last 20 years has been the idea that businesses also have responsibilities with regard to protecting human rights. So Amy, could you tell us a little bit about just the entire development of the idea of businesses and entities other than the state having human rights responsibilities, and how that applies in the context of new technological developments?
I'll do my best. So first I just want to think about the framing of this panel. A lot of the conversation over the past 2 days has been about these medium and long-term issues, but I just want to highlight the fact that some of the short-term issues are really urgent. When we look around the world and see the ways that artificial intelligence is being incorporated into surveillance in ways that potentially threaten our ability to consider these issues in the future. And at a time when there's already a lot of closing space for people who are activists and dissidents, right? These questions are actually quite urgent. So just want to remind us of that. And in that context, I think the UN Guiding Principles can be really useful because they are an existing framework for business and human rights. So I'll talk a little bit about how they were developed, and then what I see as some of the strengths and some of the weaknesses, particularly kind of broadly, and then also in the AI context. So I worked with a professor named John Ruggie here at the Kennedy School. John's terrific if you don't know him. And we basically did a huge mapping exercise trying to figure out what does human rights law have to say about companies? And we found out that, as Vivek suggested, they had very little to say directly. So these human rights instruments applied to states, and states were supposed to exercise their duty to protect against abuses by third parties, by companies, by legislating and enforcing their laws and so forth. There was a sense that because of globalization and other reasons, states weren't really doing that very well, and that there was a need for companies to also take on some kind of responsibility. And so we held a bunch of convenings around the world over the course of years, looked at what companies themselves professed to believe they should be doing, looked at what investors expected them to do, and we found that companies in essence said that they respected human rights. So we said, okay. And we created a corporate responsibility to respect human rights. And I'll talk a little bit more about what that means in a concrete way. So it is a term of art, and it in essence says that companies should not infringe on rights. So it's sort of setting a baseline or a floor, not a ceiling, as a friend of mine would say. And I think that's useful because I think there's a tendency among companies to want to talk about all the fun things technology can do, but maybe not to really focus on the adverse uses that it can have. So I think it helps pull against a natural tendency that they might have. It called for companies to have basically some process to this, so to conduct human rights due diligence. And that's more or less a management system approach. Have a policy, conduct impact assessments of actual and potential impacts on an ongoing basis. That could be during product development, it could be if you're about to launch a product in a new country, or form a new business partnership, either with a company or a government. But it gets to some of these ideas we've heard through the conference around sort of, I mean, one example would be privacy by design, right? But there's ways companies are already doing this. We laid out the idea that companies can be implicated in different ways. So they can cause these adverse human rights impacts, they can contribute to them, or they can be directly linked. And we can get into that a bit more later. It gets a little messy. And that there's a right to remedy. And the extent of a company's responsibility to provide that remedy depends on how they're connected to the abuse. So what are some strengths? The strengths are that companies are using this, right? So Fortune 500 companies like Microsoft have commitments to the UN Guiding Principles and have spent some time thinking about what this means. In fact, today I read the 90 Swiss companies just said they support a law in Switzerland that would make this human rights due diligence mandatory for Swiss companies, which is a big deal. French law also sort of incorporates this due diligence requirement. So you see actual legal movement in this space at the national level. I think the fact that it kind of creates a structural or process approach to human rights is really useful because companies can understand that, right? It takes something that seems very theoretical to them and embeds it in how they conduct business anyway. And it tells you where to start. I mean, the human rights universe, yes, it's big, but it's not that big. It's not everything in the world, right? They're enumerated, they're listed. And so that actually, I think, can be quite useful. Now, it doesn't mean they cover everything we'd ever want them to cover, and there's space to consider other things too, but it provides that baseline. And it also, the UN Guiding Principles talk a bit about prioritization. So if you have a lot of different human rights impacts through your supply chain, where do you start? You start with the most severe impacts that can't really be remediated. Oh, and lastly, it applies everywhere, regardless of government regulations. This stands alone. States have a duty to protect, and they should do that. But even if they're not doing that, you as a company still have this responsibility. And I think that's really important to bear in mind, because companies like to kind of, it's hard to remember that when they're in such a legal compliance mode, especially in the US. What are the weaknesses? Very quickly, because I know I'm short on time. But so one practical weakness that I would encourage large companies to think about is that I said, right, that these Fortune 500 companies are developing processes to implement the UN Guiding Principles, and that's great. But they're not the only ones developing this kind of technology, right? They're often buying the components from smaller companies. And so how can they incentivize through their procurement processes that these smaller companies have this reflective process built into how they develop products? There needs to be some kind of reward for that, some kind of benefit for those smaller companies, or they just won't do it, they won't build the capacity. I think this idea, there's an idea in the UN Guiding Principles around knowing and showing that you're respecting human rights. And again, I think that's been touched on here of how do you do that with something that's quite technical and opaque? And so I think there needs to be specific consideration of what that means for AI. And obviously that process is already starting with people in this room, but I think that's really important. There are real difficulties around what I call the dual use problem. It's always been an area where the UN Guiding Principles, I think, have struggled a bit. We've seen it with the financial sector as well. If you give money for something, how responsible are you for all the different ways that could be used that might be unforeseeable, at least from your perspective at the time? So, and the UN Guiding Principles definitely contemplate the dual use problem and say that you should try to make sure your products aren't used in these bad ways. But when are you responsible for remedying how they're used? And at what point do you walk away from a business relationship or a particular country where your product's being used? Those are hard questions, and the answers are not going to emerge, obviously, from the UN Guiding Principles and really need, I think, more conversation. Another area I think the UN Guiding Principles don't provide a very satisfying answer on is if you're a buyer. So say that you are a larger company and you're buying some kind of technology that you're going to incorporate into your products, and the company that's providing it, whatever they're selling to you is fine. It hasn't really been used anything for anything terrible. But they're all involved in some very nasty Orwellian surveillance system somewhere else and designing that. Do you have a responsibility not to buy their products? I don't think so far the UN Guiding Principles have gotten us through that question. And then the question of remedy is a huge one. It's, first of all, broadly a huge problem in the business and rights space writ large, right? Like because of jurisdictional issues, there often isn't legal remedy in court, although I'd love to hear that there's more than I think there is in this area. And then there's a lot of contention, first of all, with artificial intelligence. Do people even know, for example, they've suffered discrimination? Does the company that bought the AI that was in the product that discriminated, did the developers even know it was discriminating, right? We talked about all that here, but these are big problems because how can you know you have a right to remedy if you don't even know your rights were violated? And that goes, I think, to a minimum of notice that this kind of technology is being used. And then when you have all these different products bundled together, like who's really responsible for remedy when something bad happens? So I think the UN Guiding Principles is a really, really helpful start. I think we've got it as a way to start tackling these problems, but that doesn't mean there aren't lots of complicated things we can have really good discussions about.
Thank you so much, Amy. So to really delve into the application of what you discussed in terms of the UNGP's due diligence, et cetera, we're going to have Michael to tell us a little bit about what Microsoft has been doing specifically in conducting human rights due diligence on AI. So the company recently did this exercise, and Michael can tell us a little bit about it without blowing the company's secrets wide open, and we hope.
I hope also. Actually, before I kind of dive into specifics around AI-related human rights due diligence, maybe I should give a little bit of bigger picture, just to help kind of contextualize, especially what Amy was just saying, on how Microsoft is approaching its own responsibility to respect human rights. The company's commitment to respect human rights actually began in 2006 when it became a signatory of the UN Global Compact. As you might know, this is a UN CSR framework which involves 10 principles. It's very high level in nature and actually predates the UN Guiding Principles. Microsoft expanded upon that commitment in 2008 when it became a founder member of the Global Network Initiative, which Vivek has been very active in. As you might know, the Global Network Initiative is a multi-stakeholder initiative to create a kind of a human rights-based approach to the question of freedom of expression in relation to government requests for user data and content moderation. The guiding principles came out in 2011. Microsoft released its first public version of its human rights policy in 2012, and that was most recently updated in 2016. In terms of kind of bringing that policy to life, there is a human rights team, which I'm a member of. I can talk through some of the sort of day-to-day responsibilities it has. One is obviously managing and operationalizing that human rights policy and human rights related policies. If you go to microsoft.com/human-rights, you'll find the policy. There's a lot of transparency related to that. On the point of transparency, the human rights team is also responsible for some of the company's human rights transparency reporting. So an annual human rights report that we issue, as well as our biannual digital trust reports, which specifically look at the data for government and law enforcement requests for user data and content moderation. Another responsibility is, of course, human rights due diligence, which I'll come on to in a moment. Before I do that, actually, I think it's important to mention that the human rights team at Microsoft is not alone in its endeavors. In fact, far from it. Business owners are expected to identify their so-called salient human rights issues, touching upon Amy's point around prioritization. Your salient human rights issues are those which are most at risk of impact from the business. And at Microsoft, for a number of years now, we've identified our salient human rights issues as being accessibility. So that's about creating and delivering technology which is accessible for people with disabilities. Also data security and privacy, very much focused on how Microsoft itself collects, uses and stores customer data. The issue of freedom of expression, which I've already mentioned, and online safety, which historically was really focused on child sex abuse material online, but in recent years has expanded to also include the topic of extremist and terrorist content online. Obviously, there's quite a large overlap with the issues of privacy and freedom of expression. So certainly touches upon this need to counterbalance rights. How you do that online is an ongoing challenge. In terms of human rights due diligence, kind of quite a broad level before I get into the AI bit, this, as I said, is owned by the human rights team, but it's important to note that there is human rights related due diligence that happens across the business every day, whether that's in the context of privacy or accessibility or other issues as well. Of course, large businesses are quite keen to manage their risk, and that is most definitely true in online risks as well. The ideal scenario for how you manage human rights due diligence is essentially a four-stage process. You assess the risks, you implement your findings, you track your implementation, and you communicate on how effective you've been, and then you start the process all over again. In reality, many businesses, Microsoft included, are quite guilty of stopping at the first stage for a number of reasons. But what you really end up with there is a human rights impact assessment, or HRA for short, which essentially gathers dust on a shelf, or it's PDF virtual dust. And that's obviously a huge shame. I think it does speak to one of the weaknesses, unfortunately, that either exists in the guiding principles or the extent to which businesses are currently implementing the guiding principles writ large. Microsoft's experience in the space is that we have undertaken, when we think of formal human rights impact assessments, around 6 or 7 over recent years, and that includes things like Skype, Microsoft Cloud, Microsoft's market entry to Myanmar, and most recently, the impact assessment which we have finished and we're moving on to the next stages of now is in the space of AI. That was a process that we actually began around 2 years ago, which timed quite neatly with Microsoft releasing its 6 AI principles, which has become a little bit of a fashionable thing to do now for companies to release AI principles. And Microsoft's principles are privacy, reliability, inclusion, fairness, accountability, and transparency. Now, I'm saying these at a very headline level. If you want more detail, then please do view the online book, which is available free from Microsoft, it's a little plug, called The Future Computed, which looks at the future of AI, as well as policies for responsible AI, and the future of work and jobs too. Now, the AI process, the human rights due diligence process that we went through was purposely very broad in nature. It did not look at specific AI products or specific AI applications that Microsoft is currently engaged in. Instead, it looked at AI in the most broadest, holistic sense possible, which is in recognition that the technology is, of course, evolving at such a quick pace, and that we need to have quite a kind of important level set or foundation to how we think about our human rights due diligence. And also with the aspiration that actually we won't be guilty of just stopping at the assessment, but actually moving on to future stages as well. In terms of the methodology for conducting this, as I said, it was really a 2-year process. I'm glad to see Salon is in the room. Salon contributed to one of our multi-stakeholder workshops, which we held in the US. There were others that were held in Europe. And we also had bilateral stakeholder engagement around the world as well. I'm using the word stakeholder very purposely rather than rights holder. The reason being, as Amy sort of touched upon, in the context of rights holder engagement with online technologies, your rights holders can number in the billions. For example, Microsoft owns LinkedIn. There's around 575 million LinkedIn users worldwide. Something like Microsoft Windows 10, the operating system, has around 1.2 billion users worldwide. And Skype has 3 billion minutes of calls made every single day. So your rights holders really are here, there, and everywhere. So how you actually engage with them in a way in which they are informed about their rights is a significant challenge, not just in AI, but in human rights due diligence in the tech sector anyway. Through this process of these roundtables, stakeholder engagement, and of course a lot of research, we ended up with what I hope is quite a solid human rights impact assessment. And in that there were quite important findings, some of which we were a little bit surprised of. I mentioned what we consider our salient human rights issues, and to some extent they did come up in the context of AI, freedom of expression and privacy, which I know has been mentioned a few times already today, and I'm sure yesterday as well. Some of the other human rights risks which came to the surface, again, these were not sort of stop the presses, breaking news, Microsoft found something unique here. Instead, it reflected the broader research that exists elsewhere. So, for example, issues around non-discrimination, the right to work, freedom of association, and of course, right to life and security. In terms of those next steps, so continuing our human rights due diligence, we're now at a stage where we're actually looking at what we call sensitive uses. So, for example, in the context of intelligence and surveillance, as well as in the context of military uses. One quite significant challenge that came up, and actually again Amy touched upon this, is the challenge around scope of responsibility. So just to give a couple of examples, if you think around a self-driving car, there is the company that makes the car. It might be the company that provides the self-driving software that is embedded in the car system itself. There's the company that provides the telephony between the car and the data center or cloud. Again, there's another company involved there too, and the chain continues. If you have an accident, who is responsible for causing, contributing, or being linked to that accident? That is just one minor example, but actually there are many others that can exist out there. And we are seeing this time and again in some of the different sort of contexts that we are looking at now as we think around what is Microsoft's scope of responsibility, because an important point to note here, at a very kind of guiding principles nerdy level, is that if you are deemed to be contributing to a harm, then one of your responsibilities is to provide remedy. If you are deemed to be linked to a harm, then your responsibility is to use leverage to cease that harm, continue in the future. A lot to unpack there, and I've only just given you a very high-level overview. One quick final point, actually two quick final points to make. One is in the context of facial recognition. This is one of the sensitive uses that we've identified. In July, Microsoft issued a blog post which specifically called for regulation of this technology. We've noted that the company has turned down a couple of contracts to provide facial recognition technology in situations where we were quite certain or worried that the protection of human rights would not match international standards or levels which the company is comfortable with. Also in light of that, kind of recognize the need for the company to improve the problems that exist in data set bias that can very much occur in the context of facial recognition. And then Microsoft is now in the process of releasing, or creating, I should say, 6 facial recognition principles, which should be released in the next week, or maybe the week after. One kind of final challenge, I think, at a very practical level when we look at this in terms of the industry, is that, of course, Microsoft is not the only company that needs to be undertaking human rights due diligence in the context of AI. Of course, all major tech companies should be as well as companies in other industries. However, when I think about the tech sector in particular, what we see is definitely a maturity, or a spectrum of maturity, in terms of those companies out there who are really implementing the guiding principles, and therefore there is a spectrum of actual activity in terms of their human rights due diligence. And yet we are at a stage now where the human rights due diligence we are doing in the space of AI is quite repetitious. Whatever Microsoft has done is most likely to be repeated in other companies in the industry as well. So I think there is an important conversation to be had around how companies in the industry can work together so that they don't repeat the same process, spend the same amount of money, but actually achieve the same kind of results, and therefore hopefully do that in a much quicker and coordinated way.
Thank you so much for that, Michael. It's incredibly informative as to what Microsoft's doing and how the rubber hits the road. So to just sort of pull some of the themes together that have been discussed so far, I think it's interesting that we started off with a 70-year-old set of principles that then became hard law in some sense, because treaties and conventions and national constitutions were inspired by the UDHR, which have applicability in domestic legal systems. which then gave rise to a softer responsibility in the guiding principles on companies who are not the object of human rights, of the human rights system in the first place, to respect this edifice that had been built. And then the companies, in turn, have run with it and actually used it as a tool of their own decision-making. But you could also think of it as a way that they've addressed some regulatory failures, right? So to the extent that we haven't explicitly regulated certain impacts of technology and of business activity, the human rights framework and its substantive values have been used by companies and people in dialogue with companies to try to guide their behavior. For this next round, given that we have a lot of expertise on this panel on free expression in particular, and that free expression has been a right where algorithmic decision-making is very involved in moderation. I'm wondering if we could just sort of dig in a little bit on that to get a few more issues on the table before we open up for questions. So just to set the stage, companies like Microsoft and others host a lot of content. There are lots of demands coming from governments and others to moderate that content. So first of all, maybe I'll just have Jan speak a bit to this, given your European human rights expertise so what is it, you said that freedom of expression is not an absolute right. So tell us from an international human rights perspective, because we are still in the US and have a First Amendment sensibility, what is it that a government can do in terms of regulating content, and what you think is the role of a platform, perhaps, in cabining what is discussed on it?
Vivek, thank you. Well, I mean, in the specific context of freedom of expression, you've got, and the specific context of AI, you've got AI working to personalize content, to determine how an individual's content is displayed. You've got content moderation, removal, etc. As things stand, there is probably not enough transparency as to the way in which governments and platforms operate. There are some statistics, and there are some countries that are real outliers in disproportionate numbers of requests to have things taken down. But I think we're at a stage where, at the moment, seeing as we're talking about individual rights, put aside for a moment the balancing of an individual right and other rights. I don't think we're yet at a stage across the board where an individual can even know the way in which their right to freedom of expression has been interfered with. So let me just give you a very, very quick example in 3 stages by reference to AI, if I may. Is an individual always going to be aware of the scope, the extent, or even the existence of an algorithmic decision making process that might impact on his or her right to freedom of expression? The answer to that is not necessarily, right? I mean, if rights only mean something if you've got recourse. You can only have recourse if you know what you're dealing with. Secondly, and I think particularly on this interrelationship between the way in which algorithmic decision-making processes operate and any inputs coming in from regulatory authorities or governments, how do you scrutinize an artificial intelligence system? Is transparency, which has been referred to a couple of times, algorithmic transparency, necessarily going to equate to an intelligible explanation of a decision-making process? I mean, for a judge that's grown up balancing these rights, not necessarily. I mean, the courts aren't necessarily well geared at this stage to be looking at an algorithmic system being given transparency, being able to say, well, that a fair balance has been struck. And of course, with algorithms, if I hope I'm right in saying this, well, for content, they change all the time. So you can have a challenge on an algorithm, then it's become completely academic because of the nature of the way in which these algorithms can change. And then just to make it even more difficult, if you as an individual have the transparency from which you can decide that you want to challenge the way in which decision making in respect of you is being conducted by an algorithm, right? Say you know what's going on. Some of the times you raise these complaints to decision making processes that are also algorithmic, which is, I mean, for a sort of boring conventional or human rights lawyer, is fairly extraordinary because it gives rise to concerns around natural justice, procedural fairness. You know, you're complaining about a system to really the same system. And when you add in the complexity of inputs, and if some of those inputs are coming from governments directly or indirectly, then the individual is not best placed to actually make a meaningful complaint. Hopefully that's gets some thoughts going.
Thank you for the provocation. Maybe I'll ask Nani then. So you've been doing a lot of thinking about the adequacy of human rights law as it exists, and a lot of what we've been talking about, especially yesterday, talked a bit about the, let's call it the adequacy of some of the substantive rights. But do we need new forms of procedural rights and procedural justice to deal with the advances in technology, the fact that we are going to be increasingly subject to automated decision-making in one way or another, even if it's not the final say? So where's the focus of your work with regard to the procedural update of the human rights system as opposed to the substantive update, as it were?
That's a good question. First of all, just to be clear, like, we don't litigate ourselves, so we support other organizations that engage in litigation. No matter how much I like going to court, I don't do so in Europe and on digital rights. I think one thing that's actually maybe helpful to just flag for the Americans in the room who are used to the American framework on freedom of expression, right? We were just talking about the Universal Declaration and how that fed into the different international and regional treaties. There's a very basic test set out, right, to determine whether or not limitations to the right to freedom of expression are permissible under international law. So we call it the three-part test, right? So it has to be, the restriction has to be based on law, it has to serve a legitimate aim, and it has to be proportionate, basically. It has to be necessary in a democratic society, as the European Convention puts it. So that's a slightly different framework to kind of look at restrictions of expression, and therefore also that feeds into the thinking on what platforms can do in content restriction. When it comes to the European context, we don't have as strong safe harbor principles within the European Union as you do here in the US. Which is now showing to kind of be rather problematic in the sense that a shift has been, there's kind of a push going on in putting content regulation more and more in the hands of platforms rather than keeping that as kind of a state obligation. We've seen specific legislation being adopted in countries like Germany, where you have the NetzDG, where they put, you probably will have read about it because it was quite a fuss about it at the time, in which they impose huge fines on platforms like Facebook if they don't take down what is qualified under German law as hate speech. Of course, that incentivizes overly cautious behavior. And even though we've seen some decisions here and there recently in the Munich courts of appeal, that kind of push back on that, like over deletion, so to speak. This is a very risky situation, right? You have basically a state saying, like, okay, platforms, you need to regulate this, you need to enforce our laws. And on the other hand, you have the situation that Jan just sketched, in which you as an individual, if your content is removed, or if you're a company and your content is removed, you really don't know sometimes until and you also don't always know how to be able to kind of get recourse for that. We don't have something at the moment that's equivalent to the GDPR when you have a violation of your data protection rights, but there are really clear bases for you to kind of seek recourse against private entities. So this route is really not super transparent at the moment, and that is a problem. And I guess the other problem is indeed the difficulty of actually knowing what is happening inside the machine, right? Quite often protected by claims of intellectual property, and how you call it, commercial secrets, I guess. Which means that it's also very difficult to figure out what should be challenged and what not. And this is something that we're very much in the early stages on, particularly in Europe, as to like how this is going to work out. There are some good decisions here in the US, the Houston teachers decision, but yeah, we're very much at the early stages there.
So to build on that, one of the interesting features of the guiding principles is that it's there are three pillars, right? The state duty to protect human rights, company responsibility to respect, but then remedy, right? Those whose human rights are violated are entitled to a remedy, which is primarily the responsibility of the state, but also one of the company. So Amy, could you speak a little bit about what's often known as the forgotten pillar of the guiding principles? And again, if we're thinking about this kind of automated decision-making, which is going to become more and more common, and we have companies playing a variety of different roles in the AI value chain, what does remedy from the private sector start to look like? Or how do we start to think about that?
So first thought is just that I think probably there's a need for more in the first pillar, right? So the state duty to protect and having more meaningful remedy. I do think this is stuff that can't just be left in the hands of companies to try to make all these determinations. It's particularly difficult because, as many in the room may know, on issues like hate speech, the standards are different in different countries. The US particularly is a bit of an outlier. We allow a lot more speech. So that becomes actually really complicated for companies trying to implement global policies. The remedy issue, so at a traditional legal level, the remedy issue is really complicated because of jurisdictional problems, right? And that I don't think there are that many causes of action, really. So to me, that actually seems like the starting place, because when we think about remedy from companies, it becomes really hard. I mean, first of all, the volumes are really significant, which also would be a problem for a state-based system. But I think companies may be able to be that first line, but there has to be some kind of backup. And what you find, so I'm thinking about both hate speech and freedom of expression, they're both issues, right? As people, there are a lot of instances where there's hate speech and they never do get remedy, right? And these are things that really affect people's lives. I was at an event recently at the Top Lantos Commission in Congress, where a woman journalist from India was talking about having like a deep fake of her in a pornographic scene, right? And she couldn't get this taken down. It wasn't considered hate speech by the company. She never got any other explanation, right? So there's really significant challenges. And then there's this question of responsibility. And assuming we think companies have a partial role in this, if they're contributing, then they're supposed to actually provide remedy. The mechanism can be a company-based mechanism, or it can be a state-based mechanism, but they're supposed to provide remedy. But if they're directly linked, then they don't have to. I think it's a really interesting question. I also think it's a little bit of a red herring, in the sense that you can get really, really stuck in trying to differentiate between those two. The guiding principles as they're drafted have a really, this is very nerdy, sorry, almost like a way of shifting yourself from one category to the other, depending on whether you put into place efforts to not be connected to this harm, right? So if you have like contractual language saying, you won't use our AI for surveillance, or this kind of surveillance, your racially based surveillance, that might shift you from contributing to being directly linked. So there's a lot of ambiguity, and I guess to me, maybe the focus should just be more on thinking about remedy systems that actually work.
John, want to come in quickly? Sorry.
No. Just to add to that, I mean, I think the specific context of AI, you've got linguistic problems as an individual. Not everyone can code, and a remedy isn't enough. you need as an individual to have an effective remedy, right? And in order to have an effective remedy, you need to be able to understand what has happened in the way I've set out, and then it needs to be easy for you to be able to challenge that, whether it's to a company in the first instance, subsequently to a court. So companies can do things to have internal complaints procedures, make sure that it's truly an effective remedy, i.e. you can get to someone not in 2 years, but in a matter of hours or days. But also at the court level, not all legal systems have specialized courts. In England, you've got a technology and construction court. I wonder how long that court can remain a dual court, because there's going to be a lot of volume coming in from technology over the next 10, 15 years. And I think you're going to need a judiciary who's really on top of this, and lawyers who are really, really on top of this. But of course, when we're talking about all these volumes, it can't only be those who can afford, barristers, solicitors, attorneys, who can make these challenges. And that is, I think, also, in terms of volume, something we've really got to think about in the future.
So just before we open it up, I want to see if Michael wanted to come in, and I had one piece that I would love to hear from you on, which is at Microsoft. So we can also flip the remedy conversation on its head, which is that companies sometimes seek remedies for their users on behalf of wrong acts by governments. And Microsoft has been very active in litigating against governments, especially here in the United States, that seem to be engaging behavior that violates user rights. So tell us a little bit about how you approach that at Microsoft.
Sure, there really is a lot to be said here. So forgive me if I go on too long, technically, interrupt me. But this point around the forgotten pillar I think is really important, because actually I think to some extent it actually, in the technology sector in particular, actually raises the obligation to avoid ever needing to have that pillar in the first place. But that's, in many ways easier said than done. And just to I'm looking at my notes on remedy here because it is something I think about a lot. And again, forgive me for kind of nerding out here, but I think just for kind of additional context to really think about the challenge, so that you don't think that I'm trying to make excuses for a company or any technology company, because that's definitely not my intent. But in a kind of theoretical, slightly abstract way, but hopefully not too abstract, there are 3 constituent parts to remedy. There's remedy, which is the right of the rights holder. There's accountability, which is the responsibility of the duty bearer, and punishment, which is the burden of the perpetrator. Now you can identify to some extent where a company might be in there, but actually the ultimate goal of all those 3 things is to wholly restore the victim. That's what remedy should be doing. Now, according to the UN Basic Principles on the right to remedy, and I really am nerding out here, forgive me, there are 5 elements to what full restoration could look like. And let's unpack these a little bit when we think about AI and the use of maybe legislation against governments. So one element is restitution, so restoring what has been lost. Another element is compensation, money or other trade-offs for the cost of a harm. Rehabilitation, which can be medical or psychological. Satisfaction, so acknowledging the harm, securing an apology. Guarantee of non-repetition, which I think is often the most common form of remedy in business and human rights. It's really about changing policies and processes so it doesn't happen again. Now, if I was to imagine that in some circumstance I was a victim of hate speech online, how could I have rehabilitation from a company which provides that online technology? I truthfully can't really foresee how that could happen. Now, again, this isn't intended to sort of make an excuse for any internet platform, but just to really help acknowledge some of the difficulties that exist. So what I think this means, as I kind of said at the start, is it really increases the onus on companies to avoid ever having to need to create remedy, because at a practical level, it is so very, very hard. Just to give a little bit of extra insight into that at Microsoft, Jan, you kind of touched upon this. There are these effectiveness criteria within the guiding principles. I'm sorry, I'm truly geeking out here, but actually I'm going to look for Amy to remind me of all 7 of them, because I think predictability, transparency, opportunity for continuous learning, accessible, and 3 others. It doesn't matter what the 3 others are. Anyway, at Microsoft we actually did an assessment specific. They are all very important. At Microsoft we actually did an assessment of our grievance mechanisms to see to what extent they align with the UN Guiding Principles effectiveness criteria. And Luckily, they did, which was a very good finding that we could discover. However, what was very interesting and worrisome at the same time, really goes back to this point around rights holders not knowing their rights, is that each of those mechanisms that we assess and the different teams and individuals who manage those mechanisms at a day-to-day level in Microsoft, and they can be dealing with thousands of cases across the year, there were no cases that you would really think actually constitute a human rights harm. There were grievances and complaints and people who had gripes, but nothing that would actually constitute a human rights harm. So there is this quite significant disconnect between rights holders are having harms. We know that in principle, you read it in the news. There are systems and processes through which rights holders can seek to find remedy, and actually, at least in the Microsoft case, luckily, they meet what the guiding principle suggests they should do, and yet, at least luckily for the Microsoft case, we don't find that there are these significant human rights harms. That's not to say they don't ever exist. So again, I think that does add to the point that as good as the guiding principles are as talking as to what remedy should look like, actually there is this huge gap in reality, and so it really does raise the onus for companies to prevent the need in the first place. Vivek, you mentioned the point around Microsoft and legislation against the US government. There's so much to be said here, and I've spoken a lot already. What I would recommend is that you maybe should go online and find more information about this. So one example being just search for Microsoft Ireland warrant case, and you'll find a lot of information about that. There's a lot more to be said than I could possibly bore you with now after having geeked out so much. But I think just to make one quick point here, which I know, Vivek, you're probably quite acutely aware of. In business and human rights, often the counterpart with which a business might be looking to create remedy so that a problem does not occur, or in which it might be looking to have leverage to prevent that harm occurring, can often be another private sector organization. For example, a supplier or someone who operates a mine somewhere. However, in the case of technology companies, often the counterpart you are facing up against is actually government, because it can be governments who have a different approach to how they interpret their need to protect rights versus how the businesses are looking to respect rights. And so again, there's this quite odd tension that seems to exist in the space of technology companies and how they are aiming to implement the UN guiding principles, which to some extent, the guiding principles, and we had a little bit of a discussion about this over lunch, aren't quite providing as much of a guidance and degree of principle as we would like them to. And I think kind of an important sort of concern or fear to have here is what that then means in the large uncertainty that we now face with regards to artificial intelligence.
Okay, we'll let Amy come in quickly because I know we want to have time for questions. So Amy.
This is just a really quick
Yes.
point. I think it's, some people in the room may have contributions to this question, which is, there is this idea that companies themselves can provide remedy, and obviously that sort of gets criticized a lot about the fox guarding the hen house. And it also may be why I would assume maybe you don't get the complaints about really serious human rights issues, because people who've been badly harmed by your products might not really feel like going to you for a solution. So I'll just say it's a part of the UN Guiding Principles that is both very important and just very, very challenging for structural reasons that I think I just pointed out.